At the Canadian Chamber of Commerce, I'm here on behalf of our 400 network chamber partners and boards of trade across the country, our 200,000 combined members, and more than 100 industry associations. I'm also here as a father. I can share that many representatives from Canada's digital companies also have families. We all want to ensure that law enforcement has the tools it needs to pursue criminals, especially online. I'd like to express our appreciation to the Minister of Public Safety and the Minister of Justice and their teams for the extensive back and forth over the past year. The amendments made to C-22 Part 1 addressed many of the industry's concerns, and we thank the government for acting. But when you compare C-2 Part 15 and C-22 Part 2, it's clear the government doesn't share the same concerns as the vast majority of our members at the Canadian Chamber of Commerce. I've worked in and around cybersecurity for years. I don't understand why we treat cybersecurity differently from other crimes. If a business is hacked, the business CEO must apologize. The liability is on the business, even if hackers are state-sponsored. Yet our discussions here today are not about how we can support business to further protect their systems and our data. Instead, we're talking about obliging them to install devices, open their digital doors, and give access to information to authorized persons, essentially on demand. Let's imagine this law is on the books. In a year or two, imagine hundreds, maybe thousands of investigations across multiple national law enforcement agencies and federal departments on all of our digital systems. Who's managing all those secure keys? Who's accountable for patching and updating those systems to make sure that they are secure? If I leave you with one message today, it's this: the business community supports production orders. We support urgent 24-hour production orders in exigent circumstances. But we are very concerned at the prospect of unfettered access by a government-authorized person to pull information from encrypted, secured systems. What's also puzzling about this debate is that I've had the privilege of working with some of the most talented lawyers in the country. And there is a debate right now about whether or not C-22 Part 2 requires a warrant. It is critical that the powers in C-22 Part 2 be amended to clarify this important point, especially on subsections 5, 7, 14, and 20. On the discussion of metadata, this will impose significant costs, millions of dollars, on businesses. Not just in the infrastructure to retain the data, but to manage it securely, and that it's in a usable format for law enforcement. As soon as you store large volumes of sensitive data, it becomes a cyber target. As soon as data is retained, it's a target. We recognize the importance of non-disclosure orders, but these should be limited to court-authorized actions tied to national security risks and active investigations. C-22 could also penalize successful Canadian companies that operate here in Canada, but also have operations in the United States and Europe. If you are an electronic service provider based in Canada today with customers in the United States and Europe, complying with parts of Part 2 could put you offside with law enforcement and regulators in those jurisdictions. At a time when businesses are already facing tax competitiveness pressures, tariff uncertainty, the broader economic risks that we're all facing, adding another layer of regulatory burden on Canadian companies at this particular time may incentivize them to relocate. Finally, with regards to the definition of core provider, without an amendment to this section, it potentially captures the vast majority of Canadian businesses who communicate or provide an electronic service.